If you file an opening brief with fabricated quotations, it may not matter whether it came from AI or from a human drafting workflow. In a published order out of the 2nd District Division 1, the Court of Appeal struck the opening brief, imposed $7,500 of monetary sanctions, and ordered a state bar referral. And notably, it did the monetary sanctions on the court's own motion. I'm Ron Funk with California Family Law Appellate Group. This order comes from the Court of Appeal, but the lesson is universal. If your name is on it, you own it. Every quote, every cite, every word. So here's the setup. The respondent moved to strike the appellant's opening brief after discovering numerous fabricated quotations, language falsely attributed to published decisions. The respondent characterized them as AI hallucinations. The appellant did not dispute that the fabricated quotes appeared, but called them clerical citation errors and specifically denied they were the result of AI tools. Counsel's explanation is important. He said he personally polled and reviewed authorities in Westlaw, but his draft used placeholder paraphrases, and non-lawyer staff were supposed to replace placeholders with verbatim case language and pinpoint cites, or delete anything unverified. But a small number of paraphrased placeholders supposedly remained. The court also discusses a separate issue. The brief quoted from a transcript in another matter with ellipses that masked content. The appellant offered an innocent explanation for how that transcript excerpt ended up in the record. The first line you should underline in this case is this: regardless of whether inaccuracies are the result of AI tools or some other drafting process, the signatory attorney is responsible for the brief's content and subject to sanctions. So here's an important clarification. This order is not making a factual finding that AI was used. It doesn't need to. It treats the AI label as beside the point because the duty is the same either way. Don't file false representations of law. The court then explains why these weren't minor clerical errors. It identifies 3 distinct types. First, word fragments taken from a real decision but assembled into a quotation that does not appear in the decision. Second, paraphrases presented as quotations. And third, in the worst category, invented propositions, statements attributed to a case that the case doesn't even discuss, including an example where the cited pages didn't mention fees or prevailing party status at all. That's why the court says these are more than clerical errors. Now, something that stuck out to me. The court says on the court's own motion, we award monetary sanctions. That matters because most of the time, sanctions are driven by a party's motion and the usual adversarial framing. But the rules expressly permit a court of appeal to impose sanction on motion of a party or its own motion. So this isn't unauthorized, but it is a signal. The court felt strongly enough about protecting the integrity of the briefing that it imposed monetary sanctions payable to itself. And practically, it also tells you how much court time went into this, because the court later says it spent significant time verifying the fabricated citations. There's a quote in here that can be misread, so let's be precise. Something we learned from this case. The order discusses People versus Alvarez and Nolan, where the attorneys admitted the fabrications were AI generated. Then it says, in Alvarez, the court inferred a culpable state of mind from the attorney's admission that he relied solely on AI tools because of the inherent risk of inaccurate statements of law. That admission is in Alvarez, not here in Shayan. Here, this court analogizes. The attorney admits he relied solely on non-attorney staff to convert placeholders into real quotes and pin cites. And the court says that workflow carries an inherent risk, supporting an inference of knowing and unreasonable violation, especially because the opposition papers contained additional inaccuracies. So here's the bottom line. The court is not saying we found AI use. It's saying your workflow can't outsource accuracy. Here's the interesting tension. Lawyers hear AI hallucinations and think that's ChatGPT. But legal research platforms now incorporate generative AI features too, marketed as reducing hallucination risk by grounding answers in Westlaw or practical law content. The problem is, independent evaluation has found that hallucinations can still occur in legal AI research tools, and providers' hallucination-free vibes can be overstated. So the practical point for attorneys isn't never touch AI. It's treat AI output like a junior drafter, useful for speed, never acceptable as the final authority. Quotes and cites are not decoration. They are representations to a court. Here are 3 practical pointers you can implement tomorrow. 1, if it's in quotation marks, you need a pinpoint cite and a match to the source. Every time, no exceptions. 2, add a pre-filing audit step, quick checklist where someone, ideally the signing attorney, confirms the accuracy of the few key quotes and propositions your argument depends on. 3, the big one for referral practice. It is completely normal to rely on associates, staff, vendors, and tools. But when you sign it, you own it. This order says that explicitly, and it's the rule lawyers should assume every appellate panel will enforce. One more point the court makes that I actually appreciate. It acknowledges that most of these fabricated quotes didn't even appear designed to give the appellant an advantage. The law wasn't skewed to be more favorable. And yet the court says that's not the point. Inaccurate citations can be relied on, circulated, and become, quote, law in someone's mind. So the concern is broader, the integrity of the courts and the profession. Mechanically, here's what the court ordered. The opening brief was stricken. $7,500 was payable to the clerk of the court within 30 days after the remitter was filed. A corrected opening brief was due within 10 days, and that was limited to correcting or deleting fabricated citations or quotes, plus a red line copy. And the clerk was directed to serve the order on the state bar. And importantly, the court did not dismiss the appeal, reserving that for extreme circumstances. If you want appellate proofing on the front end, order language, preservation, and record strategy, or to pursue or refer an appellate matter, you can email me at cflappellategroup@gmail.com. Thanks for watching.